Today we are going to be looking at the area of criminal law. Criminal law in the common law system differs fundamentally from criminal law in civil law jurisdictions. In common law countries, unlike in some civil law countries, there is no investigating judge representing the interests of all the parties involved. Instead, in the common law, there is a clear contest between the prosecution, i.e. the state, and the accused. As the system is adversarial, there is little cooperation between the prosecution and the defence. The criminal process can be discussed under a number of different headings, namely the police and the rights of the suspect after arrest, charging of the suspect, rights of the accused or defendant after being charged, prosecution, and the role of the courts. Let's first take a look at the role of the police and the rights of the suspect after arrest. The police represent the first step in common law criminal procedure. In the United Kingdom, the police force is divided into different independent local police forces. In the United States, different police forces are found at local, state, and federal level. Criminal procedure is similar in most common law countries, and for the purposes of the present discussion, it is proposed to limit our study to the system in place in the United Kingdom. In the United Kingdom, a suspect may be arrested by the police when they have a reasonable suspicion that he has committed an offence. The police are not required to have sufficient evidence to secure a conviction when making an arrest, but they must have some evidence establishing the possible guilt of the accused, i.e. a reasonable suspicion. Arrests are normally carried out on foot of an arrest warrant issued by a magistrate. Once arrested, the suspect or detainee is interviewed by the police, and at this stage, he is said to be in detention or in police custody. Interviews at detention stage must be recorded, and prior to and during any such interviews, the suspect is entitled to receive free legal advice from a lawyer without the police being present. If required to participate in an identification parade, also referred to as a lineup, the suspect is allowed to have his solicitor present to ensure that the proper procedure is followed. Once the first 6 hours of detention have come to an end, any further detention must be authorised by a senior police officer. For most offences, there is a 24-hour limit to detention, which may be extended by another 12 hours in exceptional cases, if the offence is a serious one. Even more exceptionally, it is possible for the police to apply to the courts for a further 96-hour extension. Otherwise, the suspect must be released or charged with a specific offence. Now let's look at charging the accused. If the police consider that they have sufficient evidence against someone, they will formally charge him with an offence. When charging a suspect, the police must fill out a charge sheet which lists the offences the accused is thought to have committed. Once charged, the suspect or detainee becomes known as the accused or the defendant. If the offence is a minor matter, such as a road traffic offence, known as a minor or non-indictable or summary offence, the police, instead of arresting and charging the accused, will instead normally serve the accused with a summons through the post. The summons is a document requiring the accused to appear or to go before the appropriate court on a certain date. Now let's look at the rights of the accused after being charged. In the United Kingdom, when in detention, the accused is entitled to free legal aid. However, once the suspect is charged, access to free legal aid is means tested. When the suspect relies on free legal aid at detention stage, the solicitor is chosen for him and comes from a list of local solicitors drawn up under the Duty Solicitor Scheme, made up of solicitors who have indicated their availability for this type of work. Such solicitors are called duty solicitors, and their inclusion on the duty solicitors list is no indication of their ability in the area of criminal law. Once charged, the defendant has a right to bail. Under established case law, bail may only be refused if the prosecution establishes that there are substantial grounds for believing that the accused may not appear for trial, or may commit further offences when out on bail, or may interfere with witnesses if given bail. At the time of arrest and of being charged, the accused will have no contact with a barrister. All legal advice is given by solicitors. Moreover, should the crime be a minor offence tried before the magistrate's court, a solicitor will probably also represent the accused in court. Normally, it is only where the offence involved is a serious crime, referred to as an indictable offence, that the services of a barrister will be considered necessary. Now let's look at the prosecution. In the United Kingdom, once the defendant is charged, the police will send a file to the Crown Prosecution Service, the CPS. It is the CPS and not the police who will decide on the basis of the evidence whether to prosecute the accused or not. At this stage, the CPS may alter the charges made by the police against the accused, frequently reducing them to make the securing of a conviction more probable. Should the CPS decide not to bring a prosecution, private individuals may decide to bring a prosecution in their place. This is a relatively rare event and is to a certain extent frowned upon by the authorities. To successfully bring a private prosecution, it is necessary to demonstrate to the court that the CPS was incorrect in coming to their decision not to prosecute the accused. Now let's take a look at the courts. For criminal matters, there are two main courts of original jurisdiction, namely the Magistrates' Court and the Crown Court. The Magistrates' Court deals with what are referred to as minor or summary or non-indictable offences, also referred to as misdemeanors in the United States. These three different terms are interchangeable and refer to offences of limited seriousness, such as drunkenness, speeding offences, etc. They are referred to as minor offences to signify the minor character of the offence. One uses the descriptive summary offence to refer to the fact that such crimes are tried without jury, i.e., the offence is tried summarily. Finally, they are called non-indictable offences because, unlike indictable offences, they do not benefit from a pre-trial hearing referred to, depending on the common law jurisdiction concerned, as an examining trial, a committal hearing, a preliminary hearing, an indictment hearing, or a grand jury hearing. As regards such minor offences, sentences are normally limited to 6 months imprisonment, although for certain offences this may be extended to 12 months. More serious offences, referred to as indictable offences, are heard before the Crown Court. Coming under the heading of serious offences are crimes such as murder, manslaughter, rape, or armed robbery. Prior to the actual trial of indictable offences before the Crown Court, there is the above-mentioned pre-hearing, which also takes place in the Crown Court, to officially record the plea of the accused. After the pre-hearing, the subsequent trial in the Crown Court is by judge and jury. At the end of the trial, the jury of 12 citizens decides upon the guilt or innocence of the defendant. Thereafter, the judge, in a subsequent sentencing hearing, imposes the sentence. However, only 5% of criminal cases actually end up before the Crown Court, as there is also another type of offence referred to as a triable either way offence. A triable either way offence is a hybrid offence that may be tried summarily by the Magistrates' Court or before the Crown Court as an indictable offence. Only less serious offences such as theft and assault are defined as triable either way offences. With triable either way offences, the accused may, after the Magistrates' Court has sanctioned his choice, choose to have a summary trial before the Magistrates' Court instead of before the Crown Court. However, the accused can insist that the matter be tried by judge and jury before the Crown Court. Sometimes, prior to the end of the trial, and often at the time the accused is being charged, the prosecution will offer the defendant a deal whereby he is promised a reduced sentence in return for pleading guilty. This is referred to as plea bargaining and has been introduced as a means of encouraging guilty pleas, thereby reducing the number of full trials before the courts. We hope you enjoyed this introduction to the area of criminal law in the common law world.